Now on to our lunch for today. And you know, we used to do our banquet in this room in the Mayflower for the convention. Today, we don't really fit our lunch. We apparently, counting our overflow rooms, and there are a couple of them, we have, I think it's like 926 people here. I want to welcome you to the 12th annual Rosenkranz Debate. And we express our gratitude, as we do every year, to the Rosenkranz Foundation for supporting this event. We love having this Saturday centerpiece for our convention, a debate between two highly prominent legal theorists. It's been quite a distinguished lecture series, a debate series, started in 2008 with Judges Posner and McConnell, then Judges Calabresi and Easterbrook the next year, Professors Epstein and William Eskridge, Paul Clement and Larry Tribe debated healthcare, Judge Kaczynski and Hadley Arkes, we had Randy Barnett and Judge Wilkinson, General McCasey debating Nadine Strawson on civil liberties, Robbie George and John McGinnis, debating the Constitution was made for a moral and religious people and is indeed suited for the government of no other. Since then, we had Eugene Volokh and Deborah Rohde, Randy Barnett and Akhil Amar, and last year, John Harris and Neo Kat Yao. To moderate this debate and introduce our speakers, who are already on stage, I want to call on the Honorable Kyle Duncan, who serves on the U.S. Court of Appeals for the Fifth Circuit. Judge?
Eugene. Thank you, Eugene. It's an honor to be here and to be asked to moderate this debate. Let me introduce the participants. This is going to take some time, given the density of the biographies that I've been handed. But Michael W. McConnell is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School and a Senior Fellow at the Hoover Institution. From 2002 to the summer of 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit. He has chaired professorships at the University of Chicago and the University of Utah, visiting professorships at Harvard and NYU. He's published widely in the fields of constitutional law and theory, especially church and state, equal protection, and constitutional structure. According to a recent study, Professor McConnell's work has been cited in opinions of the Supreme Court second most often of any legal scholar during the past decade. He is the Who's first? I don't know. He's not here.
I think it's Cass Sunstein.
Oh, okay. Well, I like you better.
I like him a lot.
Well, he's the co-editor of 3 books, Religion and the Law, Christian Perspectives on Legal Thought, and the Constitution of the United States. You're a co-editor of the Constitution of the United States.
Gouverneur Morris and I.
Well done.
You know.
Professor McConnell has argued 15 cases in the Supreme Court. He's a member of the American Academy of Arts and Sciences, the 2017 winner of the Rex E. Lee Appellate Advocacy Award, and the recipient of honorary doctorates from the Notre Dame University and the Michigan State University College of Law. He asked me to mention also that he is the recipient of the Lee Lieberman Otis Award from the University of Chicago. And finally, he served as law clerk to Supreme Court Justice William J. Brennan, Jr., and is of counsel to the appellate practice of Kirkland and Ellis. Professor Philip Hamburger is a scholar of constitutional law and its history at Columbia Law School, where he is the Maurice and Hilda Friedman Professor of Law. He's also president of the New Civil Liberties Alliance, a civil rights organization dedicated to protecting all Americans from the administrative state and other threats to constitutional rights. Before coming to Columbia, Professor Hamburger was the John P. Wilson Professor at the University of Chicago Law School. He's a member of the American Academy of Arts and Sciences, and he's served on the board of directors of the American Society for Legal History. He's twice received the Sutherland Prize and has been awarded the Henry Paolucci Walter Bagehot Book Award, the Hayek Book Prize, and the Bradley Prize. His books are, in reverse chronological order, Liberal Suppression, Section 501c3 in the Taxation of Speech, The Administrative Threat, Is Administrative Law Unlawful? A rhetorical question, right? Law and Judicial Duty, and one of my personal favorites, which I read at Columbia, The Separation of Church and State, which is a wonderful book, as are they all. Among his recent articles is Chevron Bias, another rhetorical question. George Washington Law Review 2016, which explains how Chevron deference violates due process. On to our debate. The subject is whether the Free Exercise Clause guarantees a right of religious exemptions from general laws. Just a few words about why this topic is a perfect capstone to our convention theme of originalism. Three main reasons occur to me. First, here we have a debate not between an originalist and a living constitutionalist, but between two originalists. In other words, here we have a shared commitment to a method of interpretation, but a robust and principled disagreement about what historical materials say about the meaning of the Free Exercise Clause. So much for the idea that originalism gives neat, easy answers to questions of constitutional meaning. To the contrary, as our debaters will show, originalism requires intense engagement with the history, text, and context of constitutional provisions and can lead to principled disagreement about what the Constitution means. Second, lurking in the background of this debate is the correctness of the Supreme Court's 1990 decision in Employment Division versus Smith. It will have escaped no one's attention that Smith was authored by originalism's most articulate and forceful judicial champion, the late and dearly missed Justice Antonin Scalia. And yet, Smith has been energetically criticized, most prominently by one of the debaters here, as a departure from the original meaning of the Free Exercise Clause. It is said that even Homer nods sometimes. Did Justice Scalia nod in Smith? We will hear more about this from the debaters. Third and finally, this debate addresses a question that is being asked with increasing frequency today. Earlier this year, the Supreme Court denied certiorari in a case called Kennedy versus Bremerton School District, which concerned the free speech claims of a public school football coach who was sanctioned for praying silently on the 50-yard line after games. This was not the Alabama coach after the recent LSU game, but I digress. I apologize for that. In a statement respecting that denial, Justice Alito observed that the coach still had live free exercise claims, but had not pressed them possibly, quote, due to certain decisions of this court, end quote. One of those decisions, Justice Alito continued, was Smith, which in his words, quote, drastically cut back on the protection provided by the Free Exercise Clause. Justice Alito's statement ended by saying, quote, in this case, however, we have not been asked to revisit Smith. Well, did I forget to mention that 3 other justices joined that statement? It should therefore be no surprise that whether to revisit Smith is a question asked in at least 3 pending certiorari petitions to the court. So, whether Smith correctly defined the original meaning of the Free Exercise Clause is not merely an academic question, but one with pressing relevance today. And should the court decide to revisit Smith, whether to overrule it or only to recalibrate its interpretation of the Free Exercise Clause, it will almost certainly turn to the penetrating writings of the 2 debaters we are so fortunate to have before us. Our format will be as follows. Each participant will have a 15-minute opening statement, give or take a couple of minutes according to their preferences, followed by 7 minutes for each rebuttal. A discussion will then follow, moderated by me, and then we will have questions, time permitting, from the audience. And so, I turn it over to the debaters. I will be the timekeeper. And who will be going first, gentlemen?
So I will. First of all, thank you, Kyle. Thank you, Gene. And especially thank you, Nick Rosenkranz, for organizing these events. And I also want to thank Philip. I should say it's really an honor and a pleasure to be on a stage with Philip. Again, this is not our first time to do this, but Philip is, in my estimation, possibly our country's most distinguished constitutional historian in an originalist vein. I've been reading Philip, I don't know, 25, 30 years, and so admire his work. Any of you who have not read his administrative law, Lawful, or my personal favorite, the Judicial Duty, you should really not waste any time and go out to do that. And so it's just such a pleasure to be able to have this conversation this morning. And I should say, and we were talking at lunch about this, we wanted to make clear we are going to be back in the 18th century. That's what we're going to be debating. We're going to be talking about the meaning of the free exercise concept at the beginning. There are a lot of other things one might think about. You might want to think about precedent. You might want to think about changed circumstances in particular, as we were talking about during lunch. The big change circumstance here is that we now live in an era in which religious faith of all sort is under considerable attack, which was just not true at the founding. Does that cause anyone maybe to think a little bit differently? Would that maybe have caused Nino Scalia to think a little bit differently and Smith? We're not going to be talking about that. We're both going to be talking about principles at the founding. And to help us talk through this, because so much of this is legal, technical, we thought that you should have before you the actual language of some of the legal texts that the both of us are going to be talking about. The slides here, are they seeing? Yes. So the slides here are a joint product. So these are not my slides. These are not Philip's. We put them together. We both agree that what you're going to be seeing and what we're going to be talking about are the basic historical materials. And I don't think Philip and I disagree about the facts about almost any of this. We disagree about interpretation, and so that's what we're going to be getting into. But we both believe that the first thing to look at when doing originalist interpretation under the Constitution is the relevant text. So that's what you have in front of you. I hope this is familiar I just absolutely love the first 5 words. Congress shall make no law. Why didn't they just put a period there and go home? But it goes on to say no law prohibiting the free exercise of religion. And so I'm going to be defending the idea that the most probable meaning of that language is that Congress, and now with the application to state and local governments in general, can't pass laws that have the effect of prohibiting the free exercise of religion. And so if, for example, there is a law that applies to everyone saying no one may ingest peyote, a psychedelic drug, that as applied to a member of the Native American church for whom peyote is their sacrament, that law is a law prohibiting the free exercise of religion. The alternative reading in Smith that I think Philip is going to be defending today is that it isn't a law prohibiting the free exercise thereof unless it is targeted at religion, unless the subject matter of the law is the free exercise of religion. So a law prohibiting the sacrament of peyote in the Native American church would be a law prohibiting the free exercise of religion. But but the Controlled Substances Act isn't about religion. Nobody was thinking about religion. It's not so these are the two possible interpretations. Want to begin, there's a lot of text here. Don't try to read it all, but just to give you a little bit of context as we talk about what's especially relevant. I want to begin just with the background understandings of I think our most important founder with respect to religious freedom, and that's James Madison. And his Memorial and Remonstrance in 1785, I think, is generally regarded as the most important statement of the philosophical backdrop of freedom of religion in America. This is, of course, before the First Amendment. This isn't about the words of the First Amendment. This is a philosophical backdrop
Michael,
for the First Amendment.
Did you edit this also?
I'm sorry?
Did you edit this as well as the Constitution?
It's part of the, well, this is actually not part of the Constitution, so no, I didn't get to edit this. I'd like to, and I mean, it's a little long, and some of the words. By the way, the actual language, I should, after last night and Attorney General Barr's talk, I can't resist pointing out that the person who actually wrote the final draft that became the Free Exercise Clause was that curmudgeonly founder Fisher Ames that Attorney General Barr referred to last night. But anyway, so back to Madison. The highlighted language right in the middle, it is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. So the idea of religious freedom, free exercise of religion, is rooted in the idea that everyone has a duty to render homage to the Creator, but only such homage as the individual believer regards as acceptable. And so an atheist is not to be compelled to go to church because the atheist does not believe that that's appropriate homage. A Jew will deliver the homage that a Jew is persuaded is acceptable to the Creator. So also Presbyterians, that covers the two of us, but Zoroastrians, you name it. The idea here is that it's a duty to God, but it's a duty which is understood in the conscience of each individual believer. And then he goes on to say this duty is precedent or precedent, both in order of time and in degree of obligation to the claims of civil society. Because it is a duty to the Creator, this exists before civil society, and it is superior in its claims. That's why it is philosophically plausible to think of the Free Exercise Clause as being a right that we exercise even in the face of neutral and generally applicable legislation, of which is the claims of civil society. And George Washington, again, this is not a constitutional interpretation. This is about his understanding of the way this new free republic will operate. He writes a letter to the Quakers, who, by the way, at the time, I think we now have a sort of a warm and fuzzy view of Quakers, who could be, but Quakers were a very controversial group at the time, the subject of a great deal of persecution in Britain and in New England as well. And Washington, being the commander-in-chief of the Revolutionary armies, did not like the fact that some people wouldn't serve in the army. Notwithstanding that claim of civil society, Washington writes them a letter saying that the conscientious scruples of all men should be treated with great delicacy and tenderness. And it is my wish and desire that the laws may always be as extensively accommodated to them, meaning to the Quakers, as a due regard for the protection and essential interests of the nation may justify and permit. Again, I think this helps us to understand why the reading that I'm going to be urging of the Free Exercise Clause is plausible, because when the idea of free exercise is then inserted as in the very first amendment in the Bill of Rights, I think that reflects the kind of attitude toward the free exercise of religion that George Washington is espousing with regard to a group that he I mean, at time of war, when he is, having trouble raising enough people for the Revolutionary Army, he believes we should accommodate to that anyway. So now let's turn to some of the legal text, because I think it's a shared view. Maybe Philip would disagree, but I don't think so. I think it's a shared view between the two of us that the best way to understand what the legal context is not a philosophical matter, but is a legal matter, is of the concept of free exercise of religion, is to look to some of the pre-First Amendment legal guarantees, and we're going to focus on the free exercise clauses of the states prior to the First Amendment. They didn't all, and I certainly don't recommend you try to read all of this, but most of the states had some kind of free exercise clause. We have every one of them here in these two slides, beginning with Rhode Island's, which is very old. Now, the dark language is the highlighting, and as you can see, most but not all, the first three, these are in chronological order, most of the provisions have what we call provisos or caveats. That is, the logical structure of these provisions. Let's just take a random, New York is here. So the free exercise and enjoyment of religious profession and worship is permitted to all mankind, provided, so there's a caveat, right? Provided that the liberty of conscience herein granted shall not be so construed as to excuse acts of licentiousness or to justify practices inconsistent with the peace or safety of this state. Rhode Island, the first one, started this off, and they're saying that so people have, or can't be punished for the exercise of religion unless they actually, note the word actually, disturb the civil peace of our said colony, and that they have the full enjoyment of their in matters of religion, they behaving themselves peaceably and quietly and not using this liberty to licentiousness and profaneness, nor to the civil injury or outward disturbance of others. So most of these provisions, not all, but most of them have this same logical structure. They say the right is protected, but not if to the disturbance of the peace and order, where the peace and order are expressed in various ways.
You have about 2 minutes.
Oh, okay.
Your yellow light's on.
So I'm sorry. The point here is that unless the basic right, prior to the caveat, does give some kind of right against what otherwise would be the law, there would be absolutely no point to the caveats. So what the caveats say is, although you have this considerable free exercise right, it's not going to extend so far as to disturb the peace and safety of the state. That's at least a kissing cousin to our modern idea of a compelling governmental interest. I actually think this is a lot more precise. I'd rather have this language than this generalized compelling governmental interest. But logically, it's pretty much the same way. And we know that this is actually the way the legal mind, judges and lawyers, thought about these provisions at the time, because People versus Phillips is the first published, oldest that we know of, published opinion interpreting any one of these free exercise provisions, and it involves a claim against a neutral and generally applicable law. This is a case in which a Roman Catholic priest is summoned under the general requirement of everyone to give evidence relevant in a criminal case, and he was called to testify to the identity of someone who brought him, who had stolen goods and had come to him in the confessional and had confessed. And the priest said, no, I can't tell you who that is. He actually, as part of the penance, had induced the person to return the goods, but he said, I can't tell you who it is, and yet he's still being called under penalty of contempt to testify. It goes to the court. This, by the way, the judge here is DeWitt Clinton. And it says, no, it talks about the New York Constitution. And it says, it must be, and they're referring to the peace and safety caveat here. And they're saying, it must be clearly made that the concealment in the sacrament of penance is a practice inconsistent with the peace or safety of the state. Then look at what he says. The language of the Constitution is emphatic and striking. It speaks to acts of licentiousness, of practices inconsistent with the tranquility and safety of the state. It has reference to something actually, not negatively injurious, to acts committed, not to acts omitted, to offenses of a deep dye and of an extensively injurious nature. It does not extend to every generally applicable law, but only to those generally applicable laws which, in the context of the practices, that is the individual's practices, not hypothetically, but the thing actually being litigated in the case itself, are of an extensively injurious nature.
Professor, do you want to wrap up? Or
that was my wrap up.
That was great.
Your Honor.
Even when former judges appear in our court, even they are subject to the time limitations. But you'll get a chance to rebut, Professor Hamburger.
I was subject to the time limit. I just didn't comply with it.
And I granted you an exemption of at least 2 minutes from the time limitation.
So let's see, we need the slides have disappeared.
Excellent.
Who is in charge of the slides? Okay, here we go. Here we go.
I thought you were in charge of the slides.
I was hoping I was.
And you will, of course, get a chance to rebut, but we will now turn to Professor Hamburger, who will also have 15 minutes, give or take.
Well, I'm most grateful to the Federalist Society and to Nick Rosenkranz for inviting me. Especially, it's an honor to be here with so distinguished a scholar as Mike McConnell. But I confess I was a little puzzled when I got here and I saw the topic. I thought we were going to debate administrative power. So I'm completely unprepared. More seriously, what does the First Amendment guarantee? Is it a freedom under equal laws, regardless of one's religion? Or is it a freedom from equal laws precisely because of one's religion? Now, that may not be the way Michael would summarize that, the question, but I think that captures the breadth of conceptual issues at stake here. In my view, and I may be wrong, but I don't think so, the First Amendment does not guarantee a general right of exemption, and Michael's defense of such a right, although very well-intentioned, and I'm deeply sympathetic with the full range of his concerns, is deeply mistaken. Now, there are all sorts of obvious non-historical arguments to be made against the proposed free exercise right of exemption. I could tell you that a general right of exemption creates moral hazard, something the founders understood, but you already know this. I could tell you that Michael's terms, public peace and good order, are astonishingly vague. For example, would abortion, public nudity, or pot smoking be contrary to good order? I don't know. I could add that these standards are highly variable, that public nudity is against good order in Richmond, but not so clearly in parts of San Francisco. I could further say that these standards leave dangerous discretion in the courts. How are the judges to measure such things? Perhaps they'll know it when they see it. But I don't want to bore you with all of this. You already know it. So let's focus on the historical evidence. I have 5 points I'd like to make. And forgive me if I go a little fast, because I actually want to get through them within the time now that I'm... So first, let's start with the text of the First Amendment. Far from authorizing constitutional right of religious exemption, the text itself bars any such right. Not permissive, it bars it. The Free Exercise Clause can be understood to prohibit a range of things. It clearly bars laws imposing unequal or discriminatory constraints. And it probably bars, as I will want to get back to later, some laws such as those interfering with religious association. But my argument today does not stake out a position on the breadth of possible meanings. Instead, my point is simply that the First Amendment does not guarantee a right of exemption. And this is plain enough from the drafting debates, where no one's recorded as even having discussed clearly a general right of exemption. And it's even more clear from the resulting text. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So that if a statute prohibits the free exercise of religion, Congress had no power ab initio to make the law. Such a statute or the severable provision, is simply unlawful and void. And there thus is no room under the First Amendment for a right of exemption. Now, this point is familiar from a range of scholarship, not just mine, but also other academics, and I must say most notably Nick Rosenkranz, who develops this notion further than anybody else. The First Amendment's text clearly simply bars a right of exemption. Second, let's turn to the texts of the state constitutions. Now, interpreting the First Amendment, Michael, quite understandably, prefers to focus on those state constitutions. But here again, I think he is profoundly wrong, although again, with the best of intentions. For one thing, no, I'm quite serious about that. We are sincerely in accord with about the dangers to religious liberty we now face. And the question is just, what can we find in the past and what will we do in the years to come? For one thing, the provisos he considers definitional, I think are actually conditions. I'm an old corporate lawyer, so I think I recognize a condition when I see it. Consider their phrasing and see, for example, New Hampshire and Maryland. Some provisions, such as New Hampshire's, end by reciting, provided he doth not disturb the public peace. Others, such as Maryland's, conclude, unless under color of religion any man shall disturb, et cetera, et cetera. Michael says these provisions are definitional, that there are limits in the substance of the guaranteed liberty, from which he concludes that religious liberty extends to whatever does not disturb the peace, et cetera. But in fact, the qualifications about peace and so forth are conditions which indicate when religious liberty can actually be denied to the persons who seem to be a threat to society. And this is evident from the very words of the provisos, which say, provided that and unless. It's also evident from the punctuation. There's usually a colon or semicolon before those words. And even the state guarantees that do not use the words provided that and unless are sometimes make clear that peaceableness is a condition of enjoying lawful freedom. See, for example, South Carolina. It spells out all denominations of Christian Protestants in this state, demeaning themselves peaceably and faithfully, shall enjoy religious and civil privileges. Protestants who are peaceable enjoy such rights. Those who are not peaceable do not enjoy such rights. The provisos thus do not reveal a right of exemption. Instead, their texts show that they are conditions. They are safety valves, allowing liberty to be denied if ever the state is threatened by religion. Now, even more devastating, I think, to Michael's claim, and it's a noble claim, but I just think simply wrong, is the substance of the protected liberty. As a preliminary matter, note that 8 of the state religious liberty guarantees confine their freedom to religious persuasion or worship, thus making the liberty much narrower than Michael, I think, assumes. More seriously, 8 of the state religious liberty guarantees, including 6 with the peaceableness provisos, define their liberty as a sort of non-discrimination, thus precluding exemption. So see, for example, Delaware, New York, Maryland, and Massachusetts and Maryland. Delaware says, and these are just examples, all persons professing the Christian religion ought forever to enjoy equal rights and privileges in the state. New York, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever hereafter be allowed. Massachusetts, no subject shall be hurt, molested, or restrained, and so forth, for worshiping God in the manner, etc. Maryland, no person ought by law to be molested in his person on a state on account of his religious persuasion, etc., and so forth. These are anti-discrimination provisions. So that even if Michael were right, that the provisos are not conditions, and I think he's clearly wrong on this, the guaranteed liberty is not a right of exemption. Now, let's step back. Let's assume, contrary to the evidence, that Michael is right about the state constitutions. My next question is, what on earth to prove about the First Amendment to the US Constitution? The First Amendment contains no public peace and good order proviso, so that even if Michael's right about such provisos in state constitutions, might he not be wrong about them in the federal constitution? It would seem so. The different phrasing suggests a different meaning, and is therefore, I think, utterly anti-textual to say that the First Amendment is the meaning Michael derives from state constitutions with provisos. I can understand being disappointed with the First Amendment's text, but I did not expect such anti-textualism in this room. Now, having considered the text, state and federal, it is now time, third, to evaluate the social context. In particular, what alliance of denominations sought a general right of exemption? What matters for understanding the constitutional question are not the words of a few scattered individuals, but the positions taken by denominations. Yet the only denomination that took a position in favor of a general right of religious exemption was the Society of Friends. And the only time they made a concerted effort to interpret a state constitutional document to guarantee a general right of religious exemption was in 1775 in Pennsylvania. Unsurprisingly, they were resoundingly defeated. Pennsylvanians joined mass marches to protest the Quaker interpretation, and then they draft the Pennsylvania Constitution to clarify its rejection of a general right of exemption. For details, I offer you an exquisitely tedious article written by myself called Religious Liberty in Philadelphia. So that even in Pennsylvania, and this is the main point, even in Pennsylvania, the Quakers' home base, they could not win. And that's telling. A general right of exemption was a non-starter. Like the constitutional text, the social context cuts against the right of exemption. Fourth, let's look at the intellectual context. Put simply, the development of religious liberty in the 17th and 18th centuries reveals a shift from conditional toleration to an unconditional religious liberty. What do I mean by this? In the 17th century, there are widespread fears that Catholics and radical Protestants are intolerant, that they will defeat their enemies not with words, but with weapons and bloodily. And that also that they might claim to be religiously exempt from their contracts, oaths, allegiance, and general laws. That's right. What shapes the development of religious liberty was not a demand for exemption, but a fear of religion, both religious intolerance and religious claims of exemption. The English response is to protect only conditional toleration, which therefore can be denied if religious minorities get out of hand. And this contingent freedom finds expression in conditions on religious liberty. For example, 17th century American charters contain the provisos Michael talks about. The 1690 Toleration Act is structured in these ways, and the theory of John Locke. In the 18th century, the fears of religious danger persisted, and conditions on religious liberty therefore remained typical in the states. And the New York Constitution, if we could look at that, illustrates this. It begins, actually, by reciting the threat from the Catholic Church. John Jay had familial and personal reasons for this, and it's not altogether admirable, of course. It says that we are required to guard against the spiritual oppression and intolerance, where with bigotry and ambition of weak and wicked priests and princes have scourged mankind. This is not really what you hope to read in an American Constitution, but there it is. So responding to this fear, the New York Guarantee limits its protection to worship, and moreover ends with a condition, provided liberty of conscience, et cetera, should not be so construed, and I think it means so construed by the people who are exercising the religion. The liberty thus can be denied to Catholics and others who interpret religious liberty to exempt dangerous practices or otherwise seem dangerous in their views. In short, a fear of claims of exemptions and of intolerance leads many states to make religious liberty conditional so that liberty can be denied when religion becomes dangerous. Now, fortunately, there's a move to reject conditions and make religious liberty inalienable. The 1776 Virginia Bill of Rights takes this view. Jefferson does it in 1775 in his act establishing religious liberty, and the First Amendment follows their path in avoiding any condition. In short, Michael gets the development of religious liberty exactly backwards. He sees a move towards a right of religious exemption, whereas in fact religious liberty had been driven by fears of religion, and that's why we see so many conditions lingering. And that's why unconditional or inalienable religious liberty comes so late. In other words, Michael's history, I fear, inverts the reality. It's almost an Alice in Wonderland world in which conditions against claims of exemption prove a right of exemption, in which Americans are moving towards exemption. I think this is an engaging but a fantastical illusion. Fifth and finally, we must examine 18th century theoretical statements that illuminate all of this. The theoretical accounts that reveal the reasoning underlying a host of legal documents, including state constitutions. They show that the provisos relied upon by Michael did not delineate exemptions, but rather rendered the liberty conditional. So let's look at the first set of theoretical statements. Oh, I see it's up there. Gershom Lyman, just a preacher, writes in 1784, everyone has an undoubted right to choose that religion and mode of worship which to him appears most agreeable to the word of God. Sounds very pleasing, enlightenment-like, unless it be such as evidently tends to destroy civil peace and government. In that case, no one ought to be tolerated. Self-preservation forbids it. Let those words sink in. The provisos about peace and good order are not limits on exemption, but are measures when no one ought to be tolerated. Another example comes from Oliver Ellsworth, a drafter of the Constitution, advocate of the Bill of Rights, and Chief Justice of the Supreme Court eventually. He says, every man has a right to worship God in that way which is most agreeable to his own conscience. If he be a good and peaceable citizen, he is liable to no penalties or incapacities on account of his religious sentiments. In other words, he's not subject to persecution. Okay, persecution's allowed, apparently, if he's not a good and peaceable citizen. These theoretical statements, and there are others, and if we could look at the second set of theoretical statements, reveal how the provisos, I think there's another slide, part 2, reveal how the provisos were understood by many contemporaries, and I think they utterly undercut the pleasing, but I think mistaken view about exemptions. And so, if we, just to sum up, if I may, I hope I'm in time, a free exercise right of exemption conflicts with historical evidence in 5 ways. It defies the text of the First Amendment. It misinterprets the texts of the state constitutions. It ignores the social context. It inverts the intellectual context, and it's repudiated by 18th century theory. In short, the free exercise right of exemption is anti-textual, non-contextual, and directly repudiated by 18th century writers. Michael's concern for religion is admirable. And I think it's fair to say that the founders may not have anticipated everything we need today. The playing field has changed, and maybe the text needs to be amended. And maybe that will be difficult to do. But I fear that a general right of exemption is a strange beast slouching towards originalism. Thank you.
Thank you, Philip. I want to give you both a short rebuttal, but since I don't want to butt up against the showcase session. So as you're rebutting, Michael, one thing I was particularly interested in that Philip said is the textualism point, meaning that to the extent that you rely on provisos in state constitutions to elucidate the meaning of the free exercise clause, what do we do with the textualism point that he made, that there are no provisos in the free exercise clause? So, for example, if the Supreme Court did decide to revisit Smith, how are they going to grapple with that problem of textualism, if it is a problem? And then when Philip rebuts afterwards, I'd like to hear from him, if the Supreme Court does decide to revisit Smith, does it need to expand, refine, correct its reasoning in Smith to the extent that that fell short of elucidating the original meaning of the free exercise clause? Michael, take a few minutes.
So I'll begin with the question that you put, Kyle. It is true there is no proviso in the First Amendment, but it isn't the proviso is not what gives the protection for free exercise of religion. The provisos are evidence that the drafters of the earlier state constitutions understood that unless they had a proviso of some sort, that the concept of free exercise of religion was, well, dangerous. Of course, it's not going to be dangerous unless it gives some kind of an exemption from the law. So the very idea that we need to protect against an expansive and unlimited interpretation of free exercise of religion is the point. And I think here the development in Virginia, so there's a debate between Virginia, in connection with the Virginia Declaration of Rights of '76, between George Mason and the young James Madison. They both have a draft and Mason's is much more limited, right? They both have a proviso. Madison's is a much narrower. Madison thinks that the free exercise of religion should be unless the preservation of equal liberty and the existence of the state are manifestly endangered. That's compelling governmental interest of a very high bar, whereas Mason says the peace, the happiness, which is a very broad term, or safety of the state. So that's a very low bar. So they're debating how big the proviso should be, and what do? They actually compromise through silence by just protecting the right itself and leaving it to future legislatures and courts to decide what the exact extent of the caveat is going to be. That's exactly what we have in the federal free exercise as well.
Michael, do you think that properly understood, the free exercise right ends up being as protective as RFRA with the compelling interest test and the substantial burden? Or is it different? I know that's speculation, but
I think that the Congress that passed RFRA believed that they were reinstating free exercise as it had existed before Smith. Mm-hmm. I think that a subsequent amendment at the time of RLUIPA had the effect of actually making RFRA a little bit more protective, because it makes it clear that each case is decided on the basis of the consequences to the government of the practice in the particular case. Mm-hmm. And I think that's an important point. Let me just say one last thing. I mean, there are a number of things, actually two things about Philip's position. One is, think if it is true that compliance with the peace and safety provisos is a condition to being tolerated at all, that would mean that anyone whose religion violates a neutral and generally applicable law cannot practice their religion, period. So the members of the Native American church who sneak off in the forest and ingest some peyote, not only are they liable for punishment for ingesting peyote, but the entire Native American church can be shut down. They will not be tolerated at all. Not only does that strike me as an extreme and almost totalitarian consequence, it is way more extreme than Smith. That is not the position in Smith, but also that never happened in America. So there was never a case in America where someone who is raising a free exercise exemption claim and thereby loses their entire right to practice their religion. Now, Philip says the Quakers, the Society of Friends, are the only people actively working for exemptions. In a sense, that's sort of true, because exemption from compulsory military service was one of the few examples of a widespread religious practice that came into conflict with generally applicable laws. But if you look to the cases where individual people are raised, so a very early case is brought by the leader of the Jewish community in Philadelphia about the practice of having the courts open on Saturday, and him being subpoenaed to participate in a case on the day of Sabbath. That's an exemption claim. He lost, but he brought the claim. Several people early on bring claims who believe that they can't swear and can't judge others, raise exemption claims against compulsory jury service. And then the first reported claim that actually gets a decision by a court is the exemption claim in People Against Phillips to protect the priest from being compelled to testify to what he learned in the confessional. So it wasn't just the Society of Friends. And one last thing, Philip says that the language actually, not only does it not compel exemptions, but that the language of equality actually works against exemptions. Well, think about that position. If that is so, not only are there no free exercise exemptions compelled, but that means that there can be no accommodations, no legislative accommodations, right? So that means that, that the military draft exemptions, which have existed from the beginning, indeed before the beginning, are not just not constitutionally compelled, but they are unconstitutional because, according to Philip's reading, they violate the equality of rights. I do not believe that's the way equality of rights is meant. I think it means that everyone has an equal right to bring these claims based upon whatever their religion happens to be. It doesn't mean that Zoroastrians' rights are going to end up to be the same as Lutherans' rights. They're, depending on the particulars of the religion, they may end up practicing, exercising a different kind of religion. But if it were true that that's what the equality language of those provisions meant, then we would be in a very radical situation in which accommodation becomes unconstitutional.
Why don't we let Philip in the last few minutes. Philip, I'd like to hear if you are as a radically totalitarian as Michael has made you out to be. And along
but well-meaning.
And a well-meaning. And along those lines, imagine that the Supreme Court, imagine the Supreme Court does revisit Smith and agrees with you. What would a free exercise right look like, and what role would judges end up having in protecting religious liberty?
Thank you, and thanks for the suggestion of totalitarianism. That's a new one. So just to clear away the underbrush for a moment here. The position that I find in the state constitutions, not to say my position, but that I see historically in the state constitutions, is a conditional religious liberty, which was the toleration that was favored in England in the 18th century based on the writings of John Locke. I had last heard him called actually a liberal philosopher, not a totalitarian philosopher, and I actually don't think it was at all totalitarian. It was actually designed to cut off their fears of what in their century seemed like a sort of totalitarianism. Now, as for my views of the Free Exercise Clause, I do not think it requires equality such that would bar statutory exemptions. There may come a point at which a statutory exemption runs into the Establishment Clause, but you have to go pretty far to get there. I'm not aware of any obvious examples of that. And I therefore think it's a mistake to suggest that a guarantee of equal religious freedom constitutionally precludes a statutory grant of exemption. Certainly, I've never taken that position. It's an interesting one. I, in fact, don't know of anyone who takes that position. So I don't think it really stands in the way of any of the arguments made here. Now, Michael is right about something. Now, it's true that the provisos, the conditions in state constitution were never actually enforced. And he thinks that's rather odd. But it's not at all surprising. The provisos were safety valves, pessimistic precautions against 17th century style dangers, which never needed to be enforced. I think it actually makes much more sense to flip around the question about enforcement. To ask Michael, if American constitutions secured a general right of exemption, why was this never enforced in the courts in the 18th century? He cites only very late cases from the 19th century. State courts in the 1770s and 1780s frequently uphold constitutional claims, even against statutes. I spent 8 years of my life traveling to county courts looking at these cases, but never on grounds of free exercise of exemption. So I would ask, where are your cases, Michael? Show us the case upholding a constitutional right of exemption from the 18th century. Show us the case in which a party even made such an argument. And having spent decades looking through records, I have never seen such a case. I might mention...
By the way, I apologize for the
not at all.
totalitarian. I shouldn't have said that.
No, you should.
That was bad of me.
I enjoyed it. It's fun.
And it isn't true.
I get much worse from my colleagues. So
that is a low bar.
So notice, Michael does not point to any 18th century source that expressly enunciates his peculiar proposition about exemption, not one. I think his views are therefore his. They may be appealing views, but they're not those of the founders. So in fact, I think his thesis is a concoction created by recombining words selectively taken from old constitutional documents. Free exercise of religion is mentioned only in only in the Virginia and Georgia constitutions. Public peace only in Massachusetts and New Hampshire. Good order only in Maryland. So where does Michael's proposal actually get stated in the 18th century? And the answer is nowhere at all. This version of free exercise of religion is a dog that didn't bark. He's asking us to listen to the sounds of silence. And to my mind, that's a bit much. How many minutes do I have? Do I have a few more?
You're fine. Have a couple of minutes, and then I will wrap us all up in the interest of
Thank you.
Of not going into the next panel.
So I think we have to confront the reality that the two central figures in standard histories, Madison and Jefferson, favored non-discrimination provisions. And that's not to say I think free exercise is just about non-discrimination. If I have time, I'll get to that. But if we see Madison's two proposals in 1776, I don't know if they're available on the screen, he interprets free exercise to require non-discrimination. His first proposal, all men are equally entitled to full and free exercise of religion according to dictates of conscience, and therefore no man or class of men ought, on account of religion, to be invested clear emoluments of privileges, nor subjected to any penalties or disabilities, etc. His second proposal, all men are equally entitled to the full and free exercise of religion, etc., unpunished and unrestrained by the magistrate. And Jefferson in 1785 says no man shall suffer on account of his religious opinions and so forth. You can read it. These are anti-discrimination provisions. And so if we're going to find a free exercise right of exemption, we have to move away from what are generally understood as the standard documents for looking at the framers. I'd like to shift gears because notwithstanding our disagreement, we agree on something fundamental, that the ground has shifted under us, religion and religious liberty is under attack. I must regret it if I am right on this. Not because I think it's a desirable standard, Michael proposals, but the current understanding of free exercise may be too weak. So what are we to do? And I'd like to suggest 3 points along these lines. I think we need the judges to do their job rather better than they have. First, on federal power, the judges have expanded congressional power so far as to threaten religious liberty. If the judges are free to expand federal power in ways that threaten religious liberty, they surely also have a power, indeed a duty, to limit that threat. For example, the judges have expanded the commerce power into a federal power to regulate private relations in the workplace and education. Whatever the merits of such regulation, the judges cannot thereby justify government assaults on religious freedom. Second, when we turn to rights, the judges need to recognize that the freedom of religious association, if they can recognize new rights of sexual association, they should also recognize the old right of religious association. At the statutory level, this means new statutory rights should not defeat the old constitutional right. For example, anti-discrimination laws force open membership in religiously oriented associations, be it a Bible reading group or a business corporation. The government is directly dictating religious fellowship and association in violation of at least the Establishment Clause, which protects us against privileges in religion. And that's exactly what happens in anti-discrimination laws. And third, we have to talk about administrative inequality. You see, it all comes back to administrative power. In Employment Division versus Smith closes, very interestingly, it notes that Americans, religious Americans, can seek relief through the political process of democratic government. It's a nice thought, and there's some merit to it if we had such a government. But the judge, well, we have it in form, but within that shell, we have something very different, an administrative state. The judges have legitimized a partial exclusion of Americans from the political process. They've justified administrative power, thereby insulating rulemakers from popular accountability and elevating rulemakers who are devoted to scientism and who are skeptical of religion. So whereas members of Congress are attentive to their religious constituents, these bureaucrats are indifferent, if not hostile. The judges, moreover, have upheld administrative limits on church speech under 501c3 of the tax code. By the way, the two provisions in the tax code limiting speech were first proposed not as a technical tax provision, but by Hiram Evans, Imperial Wizard of the KKK, which will tell you something about the nature of those provisions. All of this amounts to a partial but very serious exclusion from the political process, and it makes a mockery of the idea of equal laws. The surface of administrative rules may seem equal, but the underlying rulemaking process is a tilted game. So that even facially equal administrative rules are discriminatory against religious Americans. This is a profoundly unconstitutional inequality, a violation of free exercise and of equal protection. And the judges need to stop sitting on their hands. They need to recognize this, the realities of how we're governed now.
Philip, if I could interject,
Thank you.
Did I hear you suggesting that when a burden on religious exercise comes from an administrative agency, you don't think Smith was correct? Or you think the rationale of Smith sort of runs out there?
The rationale of Smith does not seem to apply there. Now, you can go two ways with this. You could say, aha, and now we have the pre-Smith rule that we can have a right of exemption. Personally, I think it's much easier and more consistent with the Constitution simply to recognize that inequalities can come in process as well as in the substantive rule. And this is a systematic discrimination against religious Americans and needs to be recognized.
Thank you. Now, I've been given an electronic indulgence from the powers to keep going until 2:30. So, Michael, I want to give you an opportunity to weigh in with anything else you might like to add.
So, I was
or even a question.
Inclined to go back to the history again, but did you want to go to the
well, if you want, I
audience?
tell you what, why don't you make another point, and if anybody wants to, if we could have a couple of questions before 2:30, we'd be happy to have them.
So
just proceed to the
Philip
microphone.
says that I have not invoked any 18th century evidence. There were no claims for exemption. We had an established church in every state south of Philadelphia, south of Pennsylvania. We had effectively established churches in New England. There were a couple of states in between, like Pennsylvania, and Pennsylvania is, of course, the one state that Philip recognizes where there were claims for exemption because the Quaker minority was so concerned about a military conscription. But almost immediately we start getting claims for exemption as soon as the New Republic gets underway. The claim by the Jewish merchant not to have to testify on a Sabbath in Philadelphia is, if I remember correctly, 1791. That's pretty early. Now, it is true that that's rejected, but we don't have any evidence of, we don't know why it was rejected. The report just tells us that the claim was rejected. The first published opinion that we know of under one of these provisions, 1813, that's not late 19th century. 1813 is pretty early 19th century, and it upholds an exemption claim. So, and there are no, there are no cases the other way. I mean, it's not as if people are raising exemption claims and courts are saying, oh, no, we don't do that sort of thing. So, there is a lot of absence of evidence here, but that doesn't, that I don't think gets to be dumped in my lap.
Why don't we take a couple of questions in the remaining 6 minutes? Why don't you go ahead, please, identify yourself and ask a question.
Hi, my name is Marco Peraza. I'm a 3L at Penn Law, and my question is for Professor McConnell. If we were to recognize an exemption through the Free Exercise Clause to general laws, it seems like the question about what counts as a religion becomes extremely important. It's very easy to plead a moral belief that's sincerely held, that may be even fundamental to your life. What prevents people from just claiming exemptions to any laws they don't like on that basis?
Thank you. Michael?
Well, the formal doctrine on this is that the courts can inquire into sincerity, so that so there's a case, and a lot of these cases come up in the prisons, but it's one where a group is formed whose sacrament is that they need to have a weekly sacrament of filet mignon and Bordeaux wine, and the case is called United States versus Kook. K-U-C-H, but nonetheless, and the courts make pretty fast work of the insincere claims. I think the hardest part of this isn't people making up claims. The hardest part is the boundaries between religion and conscientiously held, but not obviously religious positions. And the courts go both ways on this. I think I know every case in which one of these has been raised in the last 50 years, and there have been a few. Meanwhile, there have been 150 law review articles worrying about this problem, none of them giving a very good answer.
Thank you. Thank you. Why don't we take one from over here, please? Identify yourself and ask a question.
Devin Watkins, Competitive Enterprise Institute.
Thank you.
So to me, the free exercise seems a lot like the First Amendment in the freedom of speech context. Freedom of speech doesn't have any proviso, and yet it doesn't extend to all speech, only that isn't injurious to others. Defamation, contracts, verbal contracts for murder, things like that are not included. Because it was considered kind of a natural right. It extends to your right to do these things that aren't injurious to others. And in a similar way, I see the free exercise of religion as your right to pray or do sacraments that aren't injurious to others. And so it wouldn't extend to the right against generally applicable laws, against harming others in various ways, but it would extend a right to generally applicable laws that aren't injurious to others. Is there any way that you can see kind of a correlation between the freedom of speech and the free exercise in that way?
Well, I think your point is exactly right. All of these should be understood against the backdrop of natural rights theory. Natural rights were not understood as absolute. The initial boundaries, of course, the law, what Locke calls the law of nature, which is essentially the equal right of others to be able to exercise the same. Note that some of the peace and safety provisos specifically refer to, one of the things you can't do is to disturb the religious observances of others. Well, that's a perfect reflection of the way in which the limitations of the law of nature confine and define what the natural rights are. I think speech and religion are very similar here, and neither comes from a backdrop of absolutism. So I think to some extent, the things that Philip and I are worrying about, and we all worry about from a 20th century point of view, are a little foreign to them because of course there are going to be limitations. And so the peace and safety provisos are simply ways of stating the kinds of limitations you would expect from natural rights theory. And I think that's true of speech as well as religion.
Philip, did you want to add anything?
Yeah. The awkwardness is that in the 18th century, increasingly Americans say that religious liberty is an inalienable right, that it's owed to God, not to government. And they say that it's distinct from other rights. It's unlike other natural rights in that it's by no means can be subjected in any part to government. And that leaves us with a curious problem, doesn't it? Because it means that the right has to be sufficiently tightly defined that we're not inviting trumping mechanisms that will defeat it, such as compelling government interests and the like. So there's an awkwardness there, and that is, I think, drives some of the concerns we've seen in this debate.
So the right is unalienable according to Madison because it's right up there. It's because it's a duty toward the Creator, and a duty you can't give up. That doesn't tell us what the right is. It doesn't tell us anything about the scope of the right. Whatever the scope of the right is, we have to protect it.
But it does seem rather peculiar to define what's owed to God in terms of what's owed to one's neighbors and to government. One could define religion this way, but most people in the 18th century did not, and most people today do not. The idea that what's owed to God is limited in this way, in fact, is most unusual. And in fact, if one looks at 18th century folks who explain their claims against government, sometimes, very rarely do they say it's limited by government. I'll give you some examples. Quakers in the 17th century, often to show their spiritual purity and the depravity of the world, will walk naked as a sign. They did not even wear shoes. I think they may have kept their hats on. But otherwise, they walked naked as a sign. Women would do this in Salem in the 1680s. Some men did, some Rogerines, a group we've never heard of, a Connecticut religious dissenting group, argue for this in the 1750s. When asked to justify themselves, the Quakers and the Rogerines have a very simple answer. They say, Isaiah did it. And that's the end of the conversation. There's no explanation that this is compatible with government. That's irrelevant. There's another gentleman in Virginia who does this in Richmond 6 times. He gets imprisoned 6 times in 1792.
There was a student who did this at Berkeley not long ago.
There we go. But who's to say, these folks never say, oh, I have a duty to God, but limited, of course, by the laws of Virginia or by good order and the rest. It's just not part of the theological vocabulary.
And on that note of nudity,
yes. Let's strip.
And I would point out that Isaiah
That'll be the next panel.
I would point out that it didn't go well for Isaiah in the end. I'd like us all to join in thanking our esteemed panelists.